Hello everyone. In today's video, I'm going to talk about the due process of law. Now, as you all know that Indian Constitution in Article 21 mentions that no person shall be deprived of his life or personal liberty except according to the procedure established by law. And this was the view by Supreme Court in the beginning of our constitutional history. However, since Menka Gandhi case, this view has changed and the court accepted that the concept of due process of law is enshrined in Indian Constitution. So we are going to look into what is the meaning of these two terms, how the view from procedure established by law changed to due process of law, and what's the current stance. So we'll look into the meaning of these terms. Now, procedure established by law. As I already stated that it's enshrined in Article 21 of the Indian Constitution. Now, this was taken from the Japanese Constitution of 1946, which also uses the term procedure established by law. This concept is also enshrined in Irish Constitution, which was also referred to by our constitutional forefathers. Now, procedure established by law or procedural due process means that the executive. What is executive? Executive is your bureaucrats, the Council of Ministers, Prime Minister. So anyone who is part of government or civil services, they form the executive. So executive necessarily need to follow procedures that are prescribed by the law before depriving a person of their life or personal liberty. Now that means, say, if a law says that a person should be sent to a judicial magistrate after arrest within 24 hours, and say they have not been sent to the judicial magistrate, they have not been presented in front of judicial magistrate within that period of 24 hours, then it's a violation of their right to life and personal liberty, as executive cannot do such an action. It has to follow what the law says. If the executive does not follow that action, the court may initiate some action against the executive in that case. So now this interpretation means that the liberty can be constrained by any law passed by a competent legislature. That is, say if now the legislature passes an act that instead of 24 hours, it says a person must be presented in front of a judicial magistrate within 24 days. So then the court will not inquire into why 24 days. The court will just assume, okay, 24 days. So if you are not presented before a judicial magistrate within 24 days, it will only be a violation of your right then. Otherwise, your rights are intact because the law says so. That means procedure established by law will only prevent the arbitrary action of executive. It will not look into the reasoning behind action of a legislature. So coming to the meaning of due process of law. This principle is part of natural justice. Now I have discussed natural justice in detail in the previous slide. You can go through it if you are not sure what natural justice is. And they're also part of Magna Carta. Now Magna Carta was developed in England back in 13th, 14th century. It was there to make sure that the king does not have all the power. There's some distribution of power to ensure that there's no autonomy in one hand. Now, when the English Constitution was drafted, they didn't incorporate the concept of due process of law. They didn't even incorporate the concept of judicial review because they felt it's against democracy. However, this concept was explicitly added in US Constitution by the 5th and 14th Amendment Act. Now, due process of law has two parts. One is procedural and other is substantive. So we have already discussed the procedural due process, which is equivalent to procedure established by law. That is, it protects against the arbitrary action of executive. Now, substantive due process, it protects against the arbitrary action of legislature as well. Code goes into the substance of the act, it goes into the substance of the law to see if such a law that has been enacted is just, fair, void of vagueness, etc. Void of vagueness means that the law is understandable by everyone. Now, if a common person doesn't understand the law, how can they follow it? So if a legislature enacts a law that is not understandable to common person, it will not amount to being a just or fair law. They cannot expect people to follow it because the law is not understandable to people, and hence the court can strike it down. Now I'll explain it with the help of the same example I used for procedure established by law, that a person can be held in custody before being presented to a magistrate. From 24 hours, it's changed to 24 days. Now, earlier the court couldn't inquire into is it fair to change it from 24 hours to 24 days. However, if a constitution of a country has due process of law enshrined in it, the court can inquire into the fairness of this change as well. The court can decide as to if changing from 24 hours to 24 days is fair. Does it not violate the liberty, freedom, life of a person? If the court decides that yes, 24 days is fair, the court will uphold the law. However, if the court decides that no, 24 days is too long a period to hold a person in custody without giving them access to justice, then the court may strike the law down. So, due process of law ensures that a person has right to access the court, has right to speedy trial. None of their fundamental rights are devoid, even if the law is passed by a competent legislature, because even if it is passed by a competent legislature, the law must be fair, reasonable, and just. Now we'll look into the Constitutional Assembly debates regarding due process of law and procedure established by law. One of the major arguments against due process of law that was put forth was that it is undemocratic, as the judiciary can overrule the government which has the mandate of people. Because obviously if judiciary can inquire into the fairness, reasonableness of a legislative action, that means judiciary also has the power to overrule it. Now, a democracy is where people elect their representative, and if these representatives are bringing a law, it's assumed that it's the will of the people. So it was held undemocratic that judiciary which is not elected, which is appointed, can overrule the will of the people. It was also argued that judges may not be immune from prejudices or biases. That is, judges may have their own personal opinion coloring their judgment regarding the fairness of a legislative action. Now, the argument against procedure established by law was that it will lead to insufficient safeguard, as the legislature of the day, that is the government, can pass any law which can restrain civil liberties given to the people, civil liberties which are given to people even in the constitution. And the judiciary could only check if the executive followed the correct procedure under the law without reviewing the fact that if these laws are constitutional or not. Except like Article 13 did provide some protection, but that protection wouldn't have been enough. However, our forefathers ultimately decided that we will adhere to the concept of procedure established by law. This was mainly due to a meeting between one of the drafters of Indian Constitution and a judge of US Supreme Court. So Justice Frankfurter of US and Narsingh Rao from our Constituent Assembly, they had a meeting when this discussion was going on. Justice Frankfurter convinced Rao that it would be best if we adhere to procedure established by law. This was because at that time there was a period in US constitutional history known as Lochner era, where right to property was given a very high pedestal. And because of that, Supreme Court of United States almost nullified more than 30 acts of the US Congress. And some of these acts were related to distributive justice. These acts were related to regulating the working hour of laborers in industries. So because of these events, our Constituent Assembly was swayed that it will be better if we follow procedure established by law instead of due process of law. Not only that, we also removed, like earlier Article 21 was supposed to be life, personal liberty and property. We also removed the term property from there to ensure that property is not given such a high pedestal in our constitution. So coming to the changing opinion of Supreme Court from procedure established by law to due process of law due to expanding view of liberty. So in the A.K. Gopalan case, the Supreme Court held that the liberty guaranteed in our constitution is a qualified one, as the word personal precedes it. Now, personal liberty, according to the court, only referred to physical liberty of an individual. The court also held that all the fundamental rights are separate from each other. Hence, Article 19 has no relation to Article 21. With these views in mind, the court interpreted that it does not have power of due process of law. It can only inquire into procedure established by law, that is, if the action of executive is fair, reasonable, arbitrary or not. It does not have the power to inquire into a legislative action. Now, Justice Fazal Ali gave a dissenting judgment which stated that all the fundamental rights are linked to each other, as the freedom to movement, freedom of speech and expression, they all form part of liberty, and hence Article 19 is linked to Article 21. Now, there were many other cases that came up, but finally in Menka Gandhi case, which is a landmark case, what happened was Menka Gandhi's passport was withheld and she was not given a reason for that, neither was she given an opportunity to be heard. Now, Supreme Court, when deliberating upon this case, it held that right to go abroad is one of the right to freedom in Article 19. It also held that Article 19, the freedom guaranteed in Article 19, is linked to liberty in Article 21, and thus it stated that Article 14, 19 and 21 cannot be read separately. Hence, it gave the opinion that Indian Constitution enshrines the concept of due process of law, as the law cannot be arbitrary. The court also expanded its definition of liberty. It stated that liberty does not confine itself to personal liberty, but it also refers to one's mental liberty. That means it refers to growth of an individual, their personality, their character. Do make sure you understand the concept of liberty, because recently UPSC has made liberty as one of its favorite topic. There have been questions related to it in both 18 and 19 prelims paper. So that broad concept of liberty was defined in Menka Gandhi case itself. Now, thus the Supreme Court ultimately held that our Constitution enshrines the concept of due process of law. Coming to the present picture. Now, there have been many debates still going on if our Constitution enshrines the concept of due process of law or not. This is because the Constituent Assembly itself debated on the fact that should we enshrine the concept of procedure established by law or due process of law. And due to this, different judges in different cases have given their own opinion regarding the matter.
Issue pertains to if our courts have the power of substantive due process under Article 21 or not. Now we'll talk about few recent cases that has given different judgments related to the same concept. In the Rajbala versus Haryana case in 2015, the court explicitly stated that substantive due process is not part of Indian Constitution. This court related to the fact that Haryana government passed a law which put certain qualifications on people contesting for election of panchayat, such as they must have toilets in their home, certain educational qualifications, etc. Now, in this case, the court held that it does not have the power to inquire into the justness or fairness of this law. On the opposite end, in the Selvi case, which related to narco analysis, or the Sheikh Jahid Mukhtar case versus state of Maharashtra, which was related to beef ban and right to food, the court held that power of substantive due process is enshrined in the Constitution. Now, due to these dissenting judgments, there is confusion out there. However, one thing which the Supreme Court has made clear is that the constitutional courts will not examine the wisdom of legislative choices if the legislation does not violate any provision of the Constitution. However, if the legislation violates any principle enshrined in the Constitution, then the Supreme Court will go on to inquire if that law is fair, just, reasonable, void of vagueness, etc. Due to this, coupled with the broad interpretation of term liberty, the Supreme Court has given many rights under Article 21 to the citizens of India, such as the most recent right to privacy. Apart from that, right to free legal aid, right to speedy trial, right to food, right to work. These all rights emanate from the power of substantive due process that the Supreme Court has. Now, these rights are not enshrined in the Constitution explicitly, but as the court has already accepted a broad definition of liberty, and all these concepts such as right to privacy, food, work, they are all part of liberty of an individual. Thus, if a legislation goes against these principles, the court can strike it down owing to the lack of fairness or arbitrariness of that law. I hope this is clear because many students have this doubt. In all, you can say that since Menka Gandhi case, our constitution has enshrined the concept of due process of law as long as the legislative action violates the constitutional provisions.
Thank you, everyone. Have a good day.